First of all, I would like to welcome you all to this online panel discussion on the long-standing problem of non-execution of European Court of Human Rights judgments by Greece, the Bekir Ousta group of cases. And before we start, we would like to give some technical information, and my colleague will give you some technical details regarding broadcasting on Zoom, on Facebook and YouTube. Please, Dennis, the floor is yours.
Yes, hello everyone, ladies and gentlemen, distinguished panelists, dear participants, welcome to this webinar. Now, a few technical details I would like to give to you with respect to this webinar. Our webinar will last approximately an hour and a half, so we're scheduled to finish around 11:30 at Central European Summer time. We have today not four, unfortunately, three distinguished panelists, because one of them had unfortunately some health issues, so Mrs. Yanakaki could not be with us today, unfortunately. So I'd like to present to you Mr. Panayotis Dimitras from the Greek Helsinki Monitor, Mr. François Alfonsi, who's the member of European Parliament, who's deeply involved with respect to minority issues for a long time, of course, Mr. İlker, who's an expertise, who's a lawyer, legal counselor, who's an expertise in the present issue, which concerns us all. And of course, Mr. Harit Abipolu, our distinguished president of ABTTF, the Federation of Western Thrace Turks in Europe. So we will have, our panelists will have the presentations that will last approximately maybe 20-25 minutes, a bit more perhaps. And we will have then a Q&A session, so a question and answer session. You are all more than welcome to ask as many questions as you can in this Q&A session. Don't forget, please, dear participants, to unmute yourself when you ask your question. But just as a side note, I'd like to say that, of course, there is no camera video with respect when you ask a question. So we just require you to unmute yourself. You may raise a hand also if you have a question in the event of asking a question, and we're more than welcome to answer as many questions as we can. So I wish to all of you a very enjoyable webinar, and thank you again for this. Goodbye.
Thank you, Dennis. Honorable panelists, distinguished participants, ladies and gentlemen, good morning to all of you again. Pleasure to host this event with the support of MEP François Alfonsi, and we would like to convey our special thanks for his support on Turkish community in Western Thrace. Today's panel will discuss the issue of non-execution of the European Court of Human Rights judgments with respect to Bekir Ousta and others group of cases which the European Court of Human Rights had ruled in 2007 and 2008 regarding a violation of the freedom of assembly and association, Article 11, with respect to three associations, Kasante Turkish Union and others, which had been closed on grounds that it defended the view that there is an ethnic Turkish minority in Greece, and the non-registration of two associations, Bekir Ousta and others, and Emin and others group of cases by the national courts. Before we start, I would like to attract your attention that the resolution adopted by the Parliamentary Assembly of the Council of Europe on the implementation of judgments of the European Court of Human Rights in 2021 noted that Greece is among the countries having the highest number of non-implemented court judgments before the Committee of Ministers, with structural and complex problems, and some of which had not been resolved over 10 years, as it is case in the Bekir Ousta group of cases. To this day, applications of the three associations have still not been re-examined by domestic courts on their merits in light of the court's case law 13 years after the European Court judgments, and the two of the present association remain as of today unregistered, and the one dissolved without a convention-compliant examination of their cases by the domestic course to date. There will be an examination next week by the Committee of Ministers, and that's why we attach a great importance to today's webinar with fruitful dialogue and exchange of information with the panelists and the attendees. Before we give the floor to our panelists, I would like to give the floor to ABTTF President, Mr. Halit Habiboğlu, for his opening and welcoming speech. Please, Mr. Halit Habiboğlu, the floor is yours.
Thank you, Malik. Dear participants, our country has gained a place in the history of the world as the cradle of democracy. It is a loved country from the world's leading countries with its sea, cuisine, and hospitality. Unfortunately, our country has not reconciled with multiculturalism. While our neighbor, North Macedonia, maintains its multicultural structure, our country ignores the different cultures that exist in its midst. In the application made by our three associations, known as the Bekir Ousta and others group of cases, the European Court of Human Rights ruled against our country. Indeed, through the judgments that it took in 2007 and 2008, it ruled that our country had violated the right to form an association. Unfortunately, these judgments are still not executed by our country. One of these three associations, the Xanthis Turkish Union, is the first and oldest association established in our region. It was established in 1927. Its symbol was removed in 1983 and officially closed in 1986. The other two are our newly formed associations. The Turkish Women's Cultural Association in Rodopi province was established in 2001. If it had been allowed to be established, this year it would have celebrated its 20th anniversary. Our other association, the Everest Province Minority Youth Association, was established in 1995, but again, it was not allowed to be established. All three associations were closed and the other two were not allowed to be established for allegedly threatening the public order of our country. Despite the European Courts of Human Rights judgments, our country still insists on not executing these judgments. With this panel, we hope that our aggrieved association will be understood as not a threat our country, but rather part of its cultural world. I would like to thank all our friends who participate in our panel with their presentations. I hope that our country will now take a final concrete step towards the execution of European Courts of Human Rights judgments in the Bekir Ousta and other group of cases. Thank you.
Thank you, Mr. Halit Habiboğlu, for this opening and welcoming speech. And we would like to start now the panel discussion. And let me now introduce Mr. François Alfonsi, MEP and the co-chair of the European Parliament's Intergroup on Traditional Minorities, National Communities and Languages. I would like to present himself before I give floor to him. As an engineer by training, François Alfonsi specialized in energy issues. He co-founded the Anti-Wazir Committee at the end of the 70s to refuse the installation of a heavy fuel oil thermal plant in Acasio and build the energy autonomy of the island. Involved in all the struggles for the recognition of the Corsican people, their right to their language and to have full and complete autonomy, he co-founded the Federation Regions and Peoples Solidarity in 1994 and contributes to the rapprochement of the two countries, ecologist and regionalist. Mayor of Ossani since 2002, the Councillor of the Assembly of Corsica, he has participated for 30 years in the editorial weekly of Aritti. Elected MEP on the list led by Michel Rivasi in the South, East in 2009, his report in favor of regional languages was voted by 90% of MEPs. With the majority of the collectivity of Corsica led by Gilles Simeoni, its objective is to better consider the island fact in European policies. He is a member of the committees on industry, research and energy and regional development. And Mr. François Alfonsi was the first MEP who visited our region, the Western Thrace in 2012, which was concluded by a fact-finding report by Human Rights Without Frontiers. Please, Mr. François Alfonsi, the floor is yours.
Thank you very much, and good morning, everybody. I'm very glad to support this meeting about the situation of the Turkish minority in Greece, in Western Thrace. 10 years ago, during my first mandate in the European Parliament, I already have been involved in supporting the Western Thrace Turks for the same affair of non-execution of the judgments of the European Court of Human Rights. This attitude of the Greek state, regardless of the governments, is a negationist attitude. They are denying the historical minority of the European Union, and it is absolutely intolerable for all Democrats, particularly in the other minorities in other countries in Europe. It's threatening as well the Corsican people and all the minorities across Europe. The Greek state is also denying the European democracy, which requires the respect and the execution of the judgments of the European courts. But it's not only the Greek attitude which is a problem. Why are they doing like this against the Western Thrace Turks minority, who is allowing for so long time such comportments without any sanction? It's time to put an end to such impunity for who is attacking the basis of the European democracy. In the few days, the Committee of the European Court of Justice is going to have a new examination of these cases on the implementation of its judgment. We are 13 years after the first judgment. Next week, I'll be in Strasbourg for the session of the European Parliament. If you agree, I could be available to go at the court if they authorize it with the COVID restrictions. It cannot take more time to have justice and to restore Western Thrace people as fully European citizens with their rights and with the respect of their rights. Thank you.
Thank you, Mr. François Alfonsi. After the presentations, maybe we can discuss a little bit in detail your observations in our region in 2012 and what has changed and what has not changed since 2012 regarding the situation of the Turkish community. And now I would like to give the floor to Mr. İlker Çavuşoğlu, the legal counsel of Bekir Ousta and others group of cases, and doctoral researcher at the Human Rights Center at the Ghent University in Belgium. İlker Çavuşoğlu studied law at Aristotle University of Thessaloniki, where he obtained his bachelor degree, and he proceeded to his postgraduate studies at the Democritus University of Thrace, where he completed his master's with specialization in civil law. He actively practices law as attorney, registered with the Rhodes Bar Association, as well as founder, partner of the Vijuri law firm in Komotini. In this respect, he focuses on cases of Greek civil law as well as international law with emphasis on human rights. Since 2014, İlker Çavuşoğlu is an affiliated doctoral researcher with Ghent University, as well as a member of the Human Rights Center of the same institution. He is also a member of the European Society of International Law, and he has worked with Harvard University on the application of religious law in Western Thrace. In the academic context, he is occupied with the research and study of international law with emphasis on the phenomenon of legal pluralism in connection with human rights. He has attended a series of conferences both in Greece and abroad, while his studies has been published in international and domestic journals. And please, İlker Çavuşoğlu, the floor is yours.
Ms. Gurmaji, thank you very much for this very kind introduction. Can you hear me? Okay. The title of my presentation is the Bekir Ousta group of cases as tested against democracy-related convention principles and the obligation to implement the court's judgments. So the Bekir Ousta group of cases encompasses 3 applications originating from Western Thrace, Greece. The cases concern the already judicially ascertained violation of the right to freedom of association of the Turkish minority members. One of the cases relates to the dissolution of the Turkish Union of Xanthis, while the other 2 to the refusal of registration of the Emros District Minority Youth Association and the Rodopi District Turkish Women Cultural Association. In the following presentation, I will briefly refer to the methodology the European Court of Human Rights exerted in the testing of the treatment the applicants encountered against the norms of the Convention. Specifically, I will review the assessment of the cases in the light of the democracy-related principles the court applied. In addition, I will shortly talk on how contracting parties to the Convention are bound by the judgments of the court and the position the national judiciary took in the process of enforcement of the judgments of this group. Moreover, I will stress a number of points I believe are mistaken in the process of execution by the national authorities. I will wrap up drawing certain inferences from the handling of the cases by the court and the problematic procedure of execution of the respective judgments. In doing so, I will emphasize on the governance of freedom of association as combined with minority claims that is reflected in the standard setting jurisprudence of the court. In all the cases of the said group, the court applied an almost identical way of inspection of compliance with the Convention provisions. Despite the existence of claims for multiple violations, the court elaborated mostly on the violation of Article 11. In this respect, from the outset, it highlighted that the freedom of association includes the right of forming an association. This is very basic, this is very fundamental and important. It sounds simple, but it is important. It also stresses that, the court stresses that establishment of legal entities in order to act collectively in a subject of common interest is one of the most important aspects this right involves. In fact, the court has repeatedly noted that the way in which national law regulates this freedom and authorities apply it in practice reveals the state of democracy within that country. Even more important is the recognition by the court that alongside political parties, legal persons pursuing the protection of cultural or intellectual heritage, the search of national identity, or the affirmation of a minority conscience are also valuable for maintaining pluralism in democracy and the proper operation of the latter. In this regard, the court usually applies a consecutive set of criteria with which it juxtaposes the case-specific state conduct. The first task is to check whether national authorities' management of the situation constitutes an interference with the Convention right. Once this is ascertained, it controls whether the interference was prescribed by law and pursued a legitimate purpose. In the mentioned group of cases, the court verified that there has been an interference, one that demonstrated a legitimate purpose, that is, the protection of public order. The last part of examination involves perhaps the most essential feature of this judicial review. In this part, the judges consider whether the intervention was necessary in a democratic society, whereby the term necessary implies an imperative social need. In other words, the court can decide that the measure adopted in the national legal order was not proportionate in view of the purpose sought. In the cases at issue, the court observed that measures such as the refusal of registration or the dissolution of the union was based on a mere suspicion regarding the intentions of the founders and the activities in which they could have been engaged should the institutions had begun their operation. It added, moreover, that even if the actual purpose of these legal entities was to disseminate the idea of existence of a national minority in Greece, this does not equate to a threat in a democratic society. Specifically, in the case of the Xanthi Turkish Union, it noted that regardless of how frustrating some views can be, their dissemination cannot automatically be considered as a peril for the public order or the territorial integrity of a country. It commented further that the essence of democracy lies within the ability to resolve possible problems through open discourse. Freedom of association does not constitute an absolute right, which means that its restriction is possible, but under very certain circumstances. However, while national authorities enjoy a certain margin of appreciation, at the same time, they are under European scrutiny for their actions and deeds. More specifically, under convention principles such as democracy and pluralism, states' margin of appreciation is even more limited. Finally, the court highlighted that in a democratic society, political views articulated through peaceful means should be freely expressed through the freedom of association. As a result, the suspension of the Turkish Union and non-registration of the rest of associations on grounds of bearing the term Turkish in their title have been considered a breach of Article 11 of the Convention. Insofar as implementation of the respective judgments is concerned, similar caveats are valid. Article 46 of the Convention introduces the legal obligation on signatory states to abide by the court's judgments. This provision applies to all judgments in which the court has found a breach of the Convention. In addition, as the relevant doctrine suggests, implementation has to be full and effective. Alongside that, states that have been found in violation of their Convention commitments are responsible for reparation of the victims of the violations. Hence, it is easily understood that implementation of judgments in the Convention human rights system is compulsory. Moreover, the same system includes a separate mechanism for the monitoring of the measures adopted by the state to fulfill its obligation. In this frame, the Committee of Ministers has been entrusted with the duty of assessment of the progress made toward implementation. As regards the cases at hand, execution of relevant judgments is pending for approximately 13 years. No matter how complicated a case may be, 13 years is admittedly a very long period for the execution of a series of judgments that, according to the court, infringe, the state have found infringing fundamental human rights. In the meantime, the mentioned associations have brought their cases before the national judiciary for their re-examination in the light of the judgments of the court. Unfortunately, their applications were declared inadmissible on grounds of the principle of non bis in idem. The Committee of Ministers has repeatedly called Greece to proceed with the execution of the judgments and issued an interim resolution in 2014 because national authorities had not come up with the individual measures to be adopted with respect to these cases. In 2017, the Greek Parliament passed a law for the amendment of Article 758 of the Greek Code of Civil Procedure. This measure, according to international authorities, sought to facilitating the execution of the Strasbourg judgments. Whether this intervention was necessary or not, personally, I'm not convinced. In my opinion, even the previous version of the respective article was sufficient for the enforcement of the judgments in the national legal order. Similar reservations were inserted also in the March 2017 communication of the Greek Helsinki Monitor. In any case, the minority associations resorted for second time to the local judiciary for the re-examination of their cases, yet this was also unsuccessful. The non-bis in idem principle prevailed against the Strasbourg case law. Respectively, the Greek judiciary held that the cases have already been considered by the national courts, including arguments related to the decisions issued by the European Court of Human Rights. This is true despite the decisions of the Committee of Ministers, which noted that the obligation to fully and effectively comply with court's judgment extends to the interpretation of national legislation by domestic courts. Consequently, the amendment of Article 758 proved ineffective as a means of facilitating enforcement. Hence, the problem here seems not technical, or not only technical, as the legislator probably perceived, but derives from a misconception or lack of knowledge with respect to the relation between the national jurisdiction and the case law of the European Court. In conclusion, the previous notes make at least 2 points evident. The first is the confirmation that the right to freedom of association contains or is immediately related to forming an association. In this way, a wide range of social group activity is afforded convention protection. The second is that the standards the court sets with regard to the management of minority claims advance in the context of the right to freedom of association. This is the second point that is evident, that the court sets standards with regard to the right of freedom of association. Consequently, the case law of the European Court of Human Rights allows us to infer that ethnic diversity declared in the name of an association and pronounced by its members is in peaceful ways deserves toleration and protection in pluralistic and democratic societies. Similarly, it can be understood that absolute measures such as eradication or prohibition of ethnic or religious diversity can be replaced by open dialogue. It is sad that the state policy has been exclusionary to this sort of diversity and led to the severe interference with the freedom, with the respective freedom. Likewise, the prolonged process of execution and the defects permitting it reveal the limited willingness of the national authorities to comply with the judgments of the court. In view of the significance the court accords to the freedom of association and the reasoning it provides for its protection in the cases of the minority institutions, non-execution simply amplifies the damage done to the human rights of the applicants. Moreover, it testifies to the dismantling of rule of law and democratic values in the convention system of human rights protection. I understand that recognition of existence of a Turkish minority in the Greek territory is a political taboo or can be considered disastrous for any political party proceeds to such recognition. On the other hand, fortunately, compliance with the judgments of the European Court of Human Rights is not voluntary. Nevertheless, bearing in mind the current level of execution, I'm not convinced so far that national authorities will decisively act toward execution. In fact, I'm afraid that the authorities will seek a solution that will not be in line with the requirement of full and effective implementation. In any case, I hope that in view of the possibility of initiation of the infringement procedure, Greece will fully embrace the solution the applicants legally deserve. Similarly, I think that a possible failure of full and effective implementation will be actually a lost chance for the European human rights system to reiterate its commitment to the protection of minorities. Thank you.
Thank you, Mr. İlker Çavuşoğlu. Then we can discuss more about the infringement procedure after Mr. Dimitras' presentation. And now I would like to introduce Mr. Panayotis Dimitras, the spokesperson of the Greek Helsinki Monitor and the board member of European Implementation Network. Mr. Dimitras was born in Athens in 1953. He graduated from the Department of Economics and he completed his postgraduate and doctorate studies at the Harvard University in the US. He was a lecturer at American College in Greece, and he was an assistant professor of political science at the Athens University of Economics and Business, where he graduated and was forced to step down due to his interest in minority rights in Greece. In 2092, he was a founding member of the Greek Group for Minority Rights, and since 1993, he has been a founding member and spokesperson of the Greek Helsinki Monitor. He has also been a spokesman and secretary of the Greek Humanist Union since 2010, and he has been a member of the board of the European Implementation Network since 2018. And he has been a member of the European Humanist Federation since 2014 and Secretary General since 2020. And he has very much involved in the examination of the Bekir Ousta group of cases, and Greek Helsinki Monitor regularly sends communication to the Committee of Ministers before the examination by the Committee of Ministers in this group of cases. Mr. Panayotis Dimitras, please, the floor is yours.
Thank you, Mark. Towards the end of the presentation by İlker, you heard what to me is the most important point. The issue is not legal, it's political. You have heard here all the legal and procedural developments around the law. Let me add information. The fact that Greece does not want, unless pressured, to implement the judgments shows, and it's mentioned in one of the decisions of the Committee of Ministers, in the fact that another Turkish minority association that tried to get registered, that of Women's of Xanthis, I won't say the whole title, was rejected with the same arguments, and the Committee of Ministers has pointed that, and their case is before the European Court of Human Rights, which will at some point, probably this year, communicate it to Greece, and it will go through the same procedure, which will lead nowhere. I mean, Greece will be convicted, but then what? I add to that, this is not the issue of the Turkish minority. This is the issue of any minority that wants to claim an ethnic identity, which is not acceptable to the dominant approach of the Greek society as a whole and all political parties, meaning you cannot have an ethnic minority in Greece. Sometimes the Committee of Ministers also examines the same problem with the non-implementation of the judgments of the European Court concerning the association of the Macedonian minority, which in fact, the history starts 10 years earlier, with the first judgment against Greece in 1998. The House of Macedonian Civilization is still not registered, although there were 2 judgments by the European Court. And other Macedonian associations that were created domestically were dissolved this year in one case, or were rejected from the registry of the Ministry of Culture just last week. In both cases, by the way, the trigger of the decision of the authorities to reject currently the Macedonian associations were extreme right-wing deputies or politicians. So this is the general climate concerning minority associations. Now, concerning the Turkish association, the proof that nothing will happen unless something dramatic is done by the European institutions is last weekend. Mr. Çavuşoğlu, not the one you see here, the other one, who is Foreign Minister of Turkey, had the brilliant idea to do what the Greek Foreign Minister does from time to time, meaning the Greek Prime Minister goes to Albania and visits the Greek minority and speak about Greeks there. And the Turkish Foreign Minister, this one or the previous ones, usually visit Thrace, Western Thrace, and speaks to the Turkish minority there. The first speaks about the Greek minority and the other one speaks about the Turkish minority. But speaking about the Turkish minority is, as you heard before, a taboo. So I have on file, I have published, in fact, on my Facebook wall, the whole array of terrible condemnations of how dare he use that term by all media, from the extreme right to extreme left, and all politicians from the extreme right to extreme left. I'm sorry that Mrs. Yanakaki could not be here, because I would have asked her, or I have put her in a very difficult position to comment on the statement of her party Syriza MP from Komotini, Gümülcin, where in an article about Mr. Çavuşoğlu's visit, he spoke of the well-known, unfounded, and non-historical references about the so-called existence of a Turkish minority. End of quote. So this is the opposition party. But then, of course, when this opposition party was in government, the Bekir Ousta issue was still going on. So they have no different position, although there are individuals like Mrs. Yanakaki, like a few others in almost all parties who would think otherwise, but they won't do much because it's detrimental to their political career, unless, and this is part of what I call the theater of the absurd, they themselves are Turks. So in the same article, the Socialist Party's MP from ECtHR Xanthis spoke about the problem that we have with, the main problem is the recognition of the national identity, and we have the problem of the Turkish Union, Xanthi, and the non-restoration of the name, etc. So, but Mr. Burhan is a Turk. So everybody knows that the Turkish MPs, whether there are 2, 3, or 4, whether they come from the right-wing party or the left-wing party or the center party, are elected because in Turkish, they tell the Turkish voters that they are Turks. But if they dare to say in Greek to the Greek audience that they are Turks, then they are insulted, slandered by everybody. Not just the right, everybody. And one time, 23 years ago, when our organization tried to have all minorities, associations, and MPs make a plea for recognition of ethnic minorities, the Turkish MPs at the time, Mr. Mustafa Akifoglu, and I forget the third one, were insulted and offended even by their own parties. How dare you say that? It's a well-kept secret. Now, when you have this climate, it takes a shock for Greece to change its attitude. And the shock needs a double procedure in Europe. An infringement procedure within the framework of the non-execution of the judgments, and Mr. Alfonsi, a rule of law procedure at the level of the European Union. We have it. Greece is certainly not Hungary, it's certainly not Poland, but the issue is behaving towards its minorities, which are protected by the Charter of Fundamental Rights, and by the way, towards all those people who come as potential refugees and are pushed back, but this is better known in Europe. It shows that there is a problem of rule of law in Greece, and something around that has to happen in the European Parliament. And I would urge Mr. Alfonsi and the EFA group, with which Greek Helsinki Monitor has communicated since probably before it was even created ages ago, to look into the possibility of raising this issue under the rule of law within the European Parliament, because certainly the European Parliament, just like the Parliamentary Assembly of the Council of Europe, are stronger than mechanisms that involve the governments themselves, like the Committee of Ministers, like the European Commission. So the latter need a push from the former. I will never forget the late Mr. Papagiannakis, an MP from the left, an MEP from the left, who said, to push for those rights, we need somebody to help us, to give us the ground. If we go alone, we will be condemned to marginalization. Therefore, I think that it is high time, after what is expected to be next week. Next week, according to the latest decision of the Committee of Ministers last March, it says that if there is no information about tangible projects, the Secretariat has been instructed to prepare a draft interim resolution for the committee's consideration. So the committee will consider an interim resolution, which, however, if it says what it says last time, which is, well, urgently take measures and give me a deadline, it won't help. 7 years after the last interim resolution, we cannot have the same one. This interim resolution, we claim, needs to have an implicit reference to infringement procedures may be considered if nothing changes. What can be changed? If we claim the courts are a problem and they are a problem, the Greek government can do what the Bulgarian and the North Macedonian governments were forced to do in similar positions, to implement similar judgments against their countries, which is to take the registration procedure out of the courts and create a governmental office of merely registering every association, as long as it has the formal requirements, without looking at the content. And that's how at least North Macedonia solved the problem with, mainly with the Bulgarian minority associations. Bulgarians and North Macedonian as taboo as Macedonians in Greece, more taboo than the Turks in Greece, for that matter, but that's been solved. In Bulgaria, the implementation of that is a little more complicated, but at least at that time, you cannot blame the courts and the independence of the courts. If you have a procedural registration with a ministry, then it's the fault of the government. So if the government really wants to change that, it does not, by the way, then tell them to change the legislation and have the associations register or re-register with a similar procedure, similar to the one that we have now, and that's how we solve the issue, with the minority religious associations who are now get the legal personality without having to go to court. I don't think that Greece will do it, because actually everybody hides behind the fact that the Supreme Court and the courts will not change that, because you're asking the Supreme Court to change its own case law. It's the Supreme Court that said that those associations cannot operate because they are a danger to Greece. So why would they change that? Now, to avoid the question why the minority MPs, the Turkish minority MPs, don't do more. Well, you don't want them to be the targets of hate without any results. What kind of hate? Please look at your chart. This is excerpts of the last statement of Greece before the United Nations Human Rights Body in March, in response to a statement made by our host here, the ABTTF. Greece repeated its position and called ABTTF, insulted ABTTF as a gongo. So all of you are hosted here by a gongo who is gradually disconnected from realities on the ground and is not in a position to speak on behalf of the Greek citizens belonging to the Muslim minority in Thrace, quote unquote. Now, by the way, our association has many problems, including referrals to court for its work on racism in general. So, and as you probably know, 35 NGO activists who are denouncing pushbacks are also being sent to court in Greece. So we have that problem too. And this is why, Mr. Alfonsi, I think that the rule of law investigation in the context of the European Parliament is now necessary, so that that Parliament too, in addition to PACE, deal with this, because we need more pressure. Otherwise, the procedure right now with the Supreme Court has not issued a judgment, although the hearing was in October and they knew that they had to do it. And they didn't issue one because they will get the new decision. And then the judgment of the Supreme Court, let me tell you if they are smart what they're going to do. They are going to send it back to the appeals court because the appeals court, as you heard before, didn't examine the merits, claiming that it's a repeat of a previous effort by the Turkish Union. So the Supreme Court will say, oh, no, that's not a repeat, it's a new one. So please examine the merits. It will take another 2 or 3 years to examine the merits. And we'll be here in 2023, 2024, 2025, discussing the same issue. Can democracy in Europe accept that? This is a challenge to those who are defending democracy, mainly the 2 European parliamentary bodies, the European Parliament and the Parliamentary Assembly, much more than government or intergovernmental institutions like the Committee of Ministers, which understandably is much more reluctant to go further. Thank you.
Thank you, Mr. Dimitras. Now we have come to an end for presentations. Before I open the floor for attendees, I would like to discuss a little bit more about the rule of law. I know that the European Commission published the rule of law report for the first time and refers to the freedom of association as a basis of the rule of law in European countries. Now, I would like to ask Mr. François Alfonsi, as you heard Mr. Dimitras, what can be done in the European Parliament regarding the respect for and the protection of the rule of law in European countries, in particular in Greece?
As you know, it's a very delicate case for the European Parliament. We have cases of anti-democratic actions of European states, which are not mentioned by the Commission when they are doing the state of play of the European Union democracy. I think to the Catalan case, for instance, where democratic leaders of political parties are in jail for many, many years for being at the head of the Catalan Generalitat government when this government organized a referendum. So it's delicate when, at the contrary, we know that in many situations the European authorities are involved to condemn, as in Hungary or Polonia, many situations which are in the mainstream of the European conscience. Yes. I'm sorry to speak English very, very hard. And so it's very delicate. I had in my box a message from Greek MEPs who said to me, why are you supporting this meeting with the Turkish Thrace minority? There is no minority, but it's a very, very hard position of the Greek establishment against the Western Thrace Turks. And we need to have an action about your situation. You did a very good report with the NGO Human Rights Without Frontiers, and about 10 years ago. We can have meetings, we can have, I can and I will have a letter to the Commissioner Borrell to ask him, and to the Commissioner Suissa, to ask them about the democracy in Greece, the respect of the courts, of the judgments of the courts. And I can be, if you allow me, in Strasbourg next week, when the next decision of the court will be given, and then taking this decision, ask directly to the Commission what they think to do to obtain the respect of the decisions. It's a thing I can do. We can ask with the intergroup, I'm presiding with all the MEPs, to have a discussion about that, because, as I've said, all minorities are concerned by the inertia of the European Commission, of the European Council about these cases, being Corsica or Hungarian Romani or other minorities which are represented here in the European Parliament, can be concerned by the situation of the Turkish minority in Western Thrace. It's a political work. I hope we can obtain the attention of all the Democrats. I try in my group to make better known your situation, and I hope to obtain some involvement in the protestation. And it's this work I can do, but I can't have real operational action. It's not my post. I'm not the president of the commission. I'm not Mrs. von der Leyen. I'm only MEP. So it's what I can do. We can speak about this next week in Strasbourg if you want. I have I'm available to see somebody or to go to the court on the Wednesday morning. I think the Wednesday or even the Thursday. I think it's possible Thursday morning. I don't know when it's the best moment to be there. We can have a press conference together if you want, and it will be a contribution to better issue for your province.
Thank you, Mr. Alfonsi, for your support and for your long-term support to the Turkish community in Western Thrace in the European Parliament. And I would like to ask to Mr. Çavuşoğlu and Mr. Dimitras. Mr. Çavuşoğlu, you mentioned the problems regarding the democracy-related convention articles and their non-execution, non-implementation by Greece. And Mr. Dimitras pointed another dimension. This issue has been very politicized, and it has also related with the democratic principles and the rule of law in Greece. And from both perspectives, what would be your comment on this long pending non-implementation of the European Court of Human Rights judgments regarding the Bekir Ousta group of cases, in light of the information that there is also an EU association applied to the European Court of Human Rights, which is the Cultural Association of the Turkish Women in the Prefecture of Xanthis. And I would like to hear your opinions. The floor is yours, Mr. Çavuşoğlu.
Well, thank you for your question. From the legal perspective, which I represent at this meeting, I believe we can do the best we can within the frame of law. Politics are for the politicians, but you can be sure what what the Greek constitution provides will be, and the European Court and the European Convention on Human Rights prescribes, will be defended in full. That is what we can do from the legal perspective. So, and we are still doing, and we will keep doing that. Unfortunately, as a lawyer, I cannot say much on that. I'm not a political person myself, but as I said, whatever it has to be done in the legal perspective, you can be sure that it will be done.
Thank you. And Mr. Dimitras?
That's a very good question. And our strategy is that when the application before the European Court is communicated to Greece, it will be a very good opportunity for the court to, in fact, examine all those things, even if infringement procedures may not occur, because we have to explain that among experts of the European Convention of Human Rights and the decisions, we believe that many cases should lead to infringement procedures against various countries in Europe. But we do know that this will not happen. We do know that the Azeri exception will remain an exception, because Azerbaijan is worse than every other country in the Council of Europe. But it is a unique opportunity when the European Court will examine the application of that Xanthi Association to, in fact, bring in all those things that won't be brought through infringement, but they will be mentioned with third-party intervention, for example. And therefore, the court will, in fact, lead itself towards unofficially reviewing the non-implementation of the associations, because we have to explain to the audience that the Bekir Ousta associations did go back to the court when they were initially refused, and the court said that this is not our issue because it's pending before the Committee of Ministers. So now that a new association whose case is not pending before the Committee of Ministers will be before the court, and perhaps we may suggest to the applicants to send a letter to the court to ask for a quicker communication of the case in view of all decisions after the decision next week. We will get something which will be a stronger judgment. Now, will a stronger judgment change Greece? Well, at some point, something should happen. I don't see how else it could be done. And also, the people in the European Parliament, as Mr. Alfonsi very clearly said, if we have a decision next week, it will be a stronger case for us to go before the European authorities and ask what's going on with Greece. Obviously, if you have another judgment against Greece in 3 years' time, that will be important too. So that's the only other. Now, it's also true that we have to involve more the UN bodies, although the UN bodies are more consultative, but we have a very friendly special rapporteur on minorities, and maybe we can involve him too after the decision next week. So if one statement after the other start coming, then maybe there will be a pressure on Greece. But frankly, with the current government, which has a very strong extreme right component, and with a very nationalist tendency within the Syriza opposition, I frankly am not very optimistic. So, you can give some carrots, but Greece needs sticks more than carrots. So the European Court is the stick. And I do know from other cases, from judgments on freedom of expression, freedom of religion, involving myself in some cases, that some laws that would have not changed without first, second, third conviction of the European Court did change after that. So maybe, in fact, in the end of the day, the examination of the new case of the Xanthi women may turn out to be more vital than we think right now. Thank you.
Thank you, Mr. Dimitras. Now I will open the floor to questions and comments, but I would like to remind that any offensive and abusive language is prohibited. Then I have to interrupt if there is an intervention in abusive and offensive language. And we would like to hear your comments. Please use the raise hand button to take the floor, and you can write also your questions to the chat button. Yes, Mr. Polycarpos Adamidis, please unmute yourself. There will be no camera show off, but we will hear your voice.
Yeah. Are you listening to me now?
Yes, we can hear you.
Thank you very much. Good morning to everybody. I attended all the lectures that have been delivered by your invitees, by your panelists. So, I mean, I have to make some, let's say, fundamental comments, and of course, to place a question as well. First of all, as I understand, we are talking now about a legal procedure, because either somebody complies with the judgments of the European Court of Human Rights. Let's distinguish it from the European Court of Justice. We're talking now about the Strasbourg procedure or not. So, as far as I understood, and as far also Mr. Dimitras, if I'm not mistaken, stipulated, the Greek judicial system has corresponded duly to this judgment of the European Court of Human Rights. And now the case is pending before the Supreme Court. That's how the legal procedure goes in Greece in accordance with the Greek legal system. And that's the essence of the rule of law. When we're invoking rule of law, either we go along with it, namely the application of rules, or we choose to circumvent it. So we have to make up our minds what we want. We want the application of rule of law, or we want to disregard the rule of law. That's the first comment that I have to make. The second one has to do with, let's say, the political issue as has been arisen. So I'd like to place a question to the participants to the panel. Does everybody acknowledge that in accordance with the Treaty of Lausanne, which has been concluded in 1923, there is no Turkish minority in Western Thrace? There is Muslim minority. First, so I mean, it's something very fundamental to, let's say, stipulate, to admit, to acknowledge this very fundamental situation. And of course, there must be also a third commented question. Why there is this coloring in the map concerning Western Thrace? Why Western Thrace is being colored green? Is it a different part of Greece? Does it have any fundamental differences with respect to the other parts, the other prefectures of Greece? Does somebody, foster any other ambitions concerning Greece and these prefectures of Greece? These are my fundamental questions and comments. So to sum up with them, as far as concerns the legal prong, which is the one we're actually discussing now, the Greek judicial system has duly corresponded. So the case is before the Supreme Court. We're expecting the ruling of the Supreme Court, and then in accordance with this ruling, the other courts, namely the Court of Appeals, should have to proceed in case that the Supreme Court decides in favor of the specific petition that stands before it. That's the Greek judicial system. That's the rule of law. So as far as concerns this, there is due alignment of Greece with respect to the judgment of the European Court of Human Rights. As far as it concerns the political issue, there is a treaty, international treaty, which clearly stipulates that there is a Muslim, not a Turkish minority in Western Thrace. And now, one more question here. As far as I understand, and this is the quintessence of the ruling of the European Court of Human Rights, which has been profoundly declared, and is fully respectable, that the fundamental right of assembly cannot be violated. So, in accordance with this, I guess that if the right of our Muslim compatriots in Western Thrace is fully acknowledged and respected, namely the fundamental right of assembly of our Muslim compatriots, then the problem, whatever problem is this, will be duly resolved. So these are my basic comments, my basic remarks, both on the legal issue, which is the one, as far as I understand, that is being, let's say, reviewed right now, and as far as concerns also the so-called political issue, which has been duly resolved in 1923. Thank you very much.
Thank you, Mr. Adamidis. Thank you for not using offensive and abusive language. We are open to dialogue and discussion. And now I will pass the floor to Mr. Çavuşoğlu and Mr. Dimitras. Please, Mr. Dimitras, let's start with you.
Basically, there is one point in the comments that I just heard, which is often used, that the Treaty of Lausanne speaks of a Muslim minority and not a Turkish minority, and which basically is not correct. There was an article last week by Professor Mavrocordatos, which explained the different uses in the context of the Lausanne treaties of the term Muslims, Greeks, Turks, but in any case, there is also the European Convention of Human Rights. There are also the UN treaties, which are much more recent. And as Professor Rozakis has written in the past, former head of the deputy head of the European Court of Human Rights, among other things, there is nothing contrary to the the Lausanne Treaty when those people in Thrace who want to call themselves Turks make Turks associations. Just like, by the way, the fact that when people who have a Pomak identity or a Roma identity among the Muslim community have so many Pomak associations and so many Roma associations. So basically, if Lausanne's treaty were to be upheld, they should have been banned too. On the contrary, the foreign ministry will speaks about a thriving society and sends a long list of scores of such associations, which, by the way, we all know that most of them are enhanced, to put it mildly, by the Greek state in their performance so as to counterweight for the Turkish associations. And we also have to say that democracy means that people have to choose what their identity in many ways. And we have to remind the audience internationally, which does not know the particularities of Western Thrace, that there is a party which runs in the European elections and with mainly one issue, which is that the minority should be recognized as a Turkish minority. So it's a Turkish minority party. And when it runs the European election, it gets a sweeping majority of the votes, probably something like 80% of the Muslims in Thrace, including the majority, 2/3 of the Pomaks, and in some villages of the Pomak, like Echinos, which is near the border with Bulgaria, 90%. So it's clear, and when of course you go to Thrace and you talk to people, actually even Greeks, even Greek nationalists speak about, oh, those Turks. So we all know, this is why I said about this theater of the absurd, that this is a dominant identity, and which in fact was the official mandatory name of the minority until the military junta, when Greece considered that the danger was not Turkey, a NATO ally, but Bulgaria, a communist at the border, and it had banned the Paleo-Muslims and the Pomaks to use the Muslim term, Pomak, and the schools were called Turkish. The only language was Turkish. So you don't revert identities by decrees. The society does not change by decrees. It changes in its own in democracies. So to go back to the question, the fact that there are pending decisions before the Supreme Court is correct, except that we have to recall that the Supreme Court's previous decisions were condemned by the European Court. So if the Supreme Court produces new decisions equally condemnable, this is only to gain time. And if Mrs. Yanakaki were here, she would have told you what she told me. Then in 2017, we will get this amendment in the hope that Greece will buy time and avoid interim resolutions successfully. Because from the amendment of 2017, we are 4 years into that, and not one final decision regarding the implementation of that amendment has been taken by the Greek judicial system. Thank you.
Thank you, Mr. Dimitras. I would like to also remind to all attendees that you can watch the previous webinar, which was held in February with the participation of Ms. Yanakaki, and you can watch the full statement by Ms. Yanakaki and the discussions taking place in 2017. And Mr. Çavuşoğlu, the floor is yours.
Well, thank you. The first thing that I would like to note is that with regard to the questions we received earlier, the European Convention on Human Rights and the Council of Europe system is something very different from the system that was valid during the League of Nations period, to which the Treaty of Lausanne belongs. So we have two treaties, two international orders, very different. So it is not very good to confuse these eras of international law and international human rights law. I'm afraid that sometimes we are also confusing political arguments and legal arguments. And this is not also good. In terms of rule of law, to the extent I know from personal knowledge, I can say that in all the procedure that the associations of Western Thrace Turks observed all this time, the applicants, they fully respected the decisions and judgments of the Greek justice. What it had to be done, we did it. So there is nothing to be said on that. It is fully respected. But when we have a relation between the European legal order and the national legal order, we need to emphasize and focus on that relationship. So it is not always easy to discern what are the obligations deriving from the European legal order and what can be directly transmitted to the national legal order. So we have to be careful with this. And sometimes I think when we confuse political and legal arguments, we are trying to instrumentalize the justice. So the justice system in Greece is fully respected. And of course, in this frame of confusion, we need to avoid instrumentalizing in order to advance our arguments. Thank you.
Thank you, Mr. Çavuşoğlu. Are there any floor requests by attendees? I think we do not have. Just checking chat. Okay. And I think we have come to the end of our panel, but I would like to give 1 minute to each panelist for their concluding remarks. Mr. François Alfonsi, let's start with you.
Yes, thank you. Now, this meeting is a confirmation of the importance of the case of the Turkish minority in Greece, and I think it's a real European topic. We need to be active about this. We have the force of the judgments of the European Court of Human Rights, and it's very important for us to value these judgments and to ask to the Greek government and to the Commission how they can act to give more implementation to the judgments. I have to ask it directly to the Commissioner, Suissa and Borrell, and I hope, I think I can write also to the Greek ambassador with the European Parliament. I don't know how he can give an answer, but we'll see. We'll see what is his answer. I see that the deep thinking of this person is that there is no Turks in Thrace. It's foolish, because the Muslims of Thrace are not Indonesians. They are not Moroccans. They are from the Turkish story. They are coming from the Turkish story, and then we need to give them their identity, because deny the identity of a people, it's a very, very important aggression against democratic rights. And I think we have a very strong case, but we have a very strong opposition to this case with the Greek government and all the complicity of all the other governments, but we can't be in the European Union and deny the judgments of the European Court of the Human Rights. It's not possible, and we have to insist on this case.
Thank you, Mr. Alfonsi and Mr. Dimitras, for your concluding remarks. Floor is yours.
Thank you. Basically, I use the time to add one information. The argument about the Lausanne Treaty was in fact presented in details in the three judgments, in the three cases before the European Court, and the European Court in all three cases rejected it as relevant. Therefore, the issue invoking the Treaty of Lausanne to deny associations to be called Turkish, or to deny any collective use of the Turkish minority term for those that want it, is contrary to the European Convention of Human Rights, with a final and irrevocable three judgments of the European Court. And that settles the issue. In Greece, people don't know it because, by the way, Greek media never report about those things. Thank you very much for everything.
Thank you, Mr. Dimitras and Mr. İlker Çavuşoğlu.
Thank you. I would like to say that in case we reach to the position of decisive implementation, I hope authorities will not deviate from the very basic principle of full and effective implementation. On the other hand, I'm very curious to see what the developments will be next week at the European level. Thank you for the invitation.
Thank you for all the panelists and attendees, and thank you for the fruitful discussion that we had today. And as a moderator representing ABTTF, we would like to see the Committee of Ministers to consider today's discussion, considering the fact that the issue is also a legal and a political one. We would like to see the Committee of Ministers to have a strong decision on the Bekir Ousta group of cases, and I hope this will contribute to the solution of this pending non-execution of the European Court judgments in the Bekir Ousta group of cases. And as a last thank you, I would like to thank you for the technical team and the interpreter for making this today's panel in both languages, in Greek and English. And we have come to end. Thank you all again.